For today's United States Supreme Court case, we turn our attention to the issue of immigration and whether or not states can bring a complaint against the federal government in terms of how it enforces or doesn't enforce immigration law. Immigration law is thought to be the exclusive province of the federal government. There is certainly language in the United States Constitution that seems to suggest exactly that they have the ability to determine the rules for immigration. And it's up to the federal government to enforce those laws or not. So can states say, hey, you're not enforcing your laws properly, or some rules are incompatible with your law? What are the rules of the states vis-a-vis federal law, vis-a-vis immigration? Let's get started with this. In 2021, the Secretary of Homeland Security promulgated new rules that prioritize the arrest and removal from the United States of non-citizens who were suspected of terrorism or dangerous criminals who unlawfully entered the country only recently. For example, the state of Texas and Louisiana claim the guidelines are contravening two federal statutes that they read to require the arrest of certain non-citizens upon release from prison or entry of a final order of removal. So the United States government says we are going to prioritize people to deport who are terrorists or dangerous criminals or recent people who have come to the United States. And the state of Texas is like, well, there are some other laws. You're required to arrest non-citizens as they come from prison. So after they're done with their time, you have to arrest them and deport them. And other people who have been given an order to be removed, you got to arrest and deport them. The district court found the states would incur cost due to the executive failure to comply with these statutory mandates, and the states had standing to sue based on the cost. So what is the basis of the states to sue? Is a pocketbook injury. By not doing this, you're creating a burden on us by having these people potentially in our states, creating a pocketbook injury for us. On the merits, the district court found the guidelines unlawful and vacated. The Fifth Circuit declined to stay the district court judgment, and this court granted certiorari to review it. So held, Texas and Louisiana lack standing to challenge the relevant guidelines. So yes, as it turns out, there might be some federal law, but this is federal law, and Texas and Louisiana do not have injury enough to have standing. Under Article 3, a plaintiff must have standing to sue. The threshold question is whether states have standing. Based on court precedent, not so much. To establish standing, a plaintiff must show an injury in fact that is caused by the defendant and redressable. Have you been harmed? Is it due to what they did? Is there something we can do about it? The district court found the states would incur costs due to challenge policy, and monetary costs are an injury. But this court has stressed that alleged injury must be legally and judicially cognizable. So maybe there's an injury, but not one that is legal or legally recognized. That would require that the dispute is traditionally thought of as capable of resolution through a judicial process. Here, the states cite no precedent, history, or tradition of federal courts entertaining lawsuits of this kind. On the contrary, the court has previously ruled that where a plaintiff lacks standing to bring such a suit, when he himself is neither prosecuted nor threatened with prosecution. The relevant case law standing principle remains the law today, and states have pointed to no case or historical practice that would hold otherwise. There are good reasons why federal courts have not traditionally entertained lawsuits of this kind. For one, when the executive branch elects not to arrest or prosecute, it does not exercise coercive power over individual liberty or property, and thus does not infringe upon interests the courts are called to protect. So the executive branch, by not arresting someone, is not harming them because they're not arresting them. They're exercising prosecutorial discretion. So that is not creating a harm to them because, well, they're not being subject to the court's whim. Moreover, such a lawsuit would run up against the executive's authority to decide how to prioritize and aggressively pursue legal actions against defendants who violate the law. So yeah, just basically prosecutorial discretion, right? There's a lot of people breaking a lot of laws. There's finite resources, even for the federal government. How are we to allocate these resources? It is up to the states to determine that. It's up to the executive to determine that, as the case may be. So all that stuff, and going from there. The principle of the executive branch enforcing discretion over arrests and prosecutions extends to the immigration context. Courts also generally lack meaningful standards for assessing the propriety of enforcement choices in this area, which are invariably affected by resource constraints and regularly changing public safety and public welfare needs. That is why this court has recognized that federal courts are generally not the proper forum for resolving claims the executive branch should make more arrests or bring more prosecution. Sounds suspiciously like what we call a political question. It's up to the executive to determine how to do this. Please leave the courts out of it. This holding does not suggest that federal courts may never entertain cases involving the executive branch's alleged failure to make more arrests or bring more prosecution. First, this court has adjudicated selective prosecution claims under Equal Protection Clause, in which a plaintiff typically seeks to prevent his or her own prosecution. Second, the standing analysis might differ when Congress elevates de facto injuries to the status of legally cognizable injuries were addressable by court. Third, the standing calculus might change if the executive branch wholly abandons its statutory responsibilities to make arrests or bring prosecutions. Fourth, a challenge to an executive branch policy that involves both arrest and prosecution priorities and provision of legal benefit or legal status could lead to a different standing analysis. Fifth, policies governing the continued detention of non-citizens who have already been arrested arguably might raise different standing questions than arrest or prosecution policies, but this case presents none of those scenarios. So the court leaving itself some outs for some potential futures based on executive non-action, but that isn't this case. The discrete standing question raised by this case rarely arises because federal statutes that purport to require the executive branch to make arrests or bring prosecutions are rare. This case is different from those in which the federal judiciary decides judiciable cases involving statutory requirements or prohibitions on the executive because it implicates the executive branch enforcement discretion and raises the distinct question of whether the federal judiciary may in effect order the executive branch to take enforcement action. The court's decision does not directly indicate any view on whether the executive complying with the statutory obligations, nor does this court narrow holding signal any change in the balance of powers between Congress and the executive. Kavanaugh delivers the opinion of the court in which Roberts, Sotomayor, Kagan, and Jackson join. Gorsuch concurs, and with Thomas and Barrett. Barrett concurs. Alito files a dissent in an 8-1 decision. Thus, that brings us to the end of the case of United States versus Texas, in which Texas complains the United States is not properly enforcing immigration law. But as the United States Supreme Court reminds Texas, this is a matter for the federal government and up to the federal government in terms of its execution. And the federal government has the ability to prioritize how it goes about different things, and different executives might make different choices. So the United States is not enforcing the law the way it wants, but that is in the nature of prosecutorial discretion and the nature of the executive discretion. So Congress could presumably do something different in trying to create damages or giving states the ability to sue, but they haven't done that, so it's up to the executive. And that, for the moment, brings us to the end of discussion of this story.